Good afternoon. I can see participants are joining apace, but we'll crack on as we have quite a lot to get through. So welcome to today's Decanar. I will be speaking about credit hire, and my colleague from Chambers, Roger, will be speaking about fundamental dishonesty. You should, I hope, all be able to see the slides which are shared on screen. And so without further ado, we will leap into my section on credit hire. I should say, as a preliminary point, we've had a few very interesting questions that have been pre-submitted, and I will endeavour to deal with those so far as they relate to credit hire at the appropriate juncture in my talk when I'm dealing with the same topic. So welcome to those who've just joined. We're going to leap in now with credit hire. So what am I going to be talking about today? Brief overview. Firstly, I'm going to be looking at financial disclosure, and that's both pre-action disclosure and the implications of dishonesty in relation to disclosure. Secondly, pleading. Thirdly, issue of call recordings and how they might impact on the enforceability of the hire agreement. Fourthly, impecuniosity in a recent case on that. Fifthly, the well-worn issue of claims for loss of profits when the vehicle that's damaged is a profit-earning chattel. Then illegality, and there's an interesting recent case on that. And finally, non-party costs orders. So financial disclosure, then the first topic. There's a very interesting recent High Court case, Holt and Alliance, which goes to that. It's an appeal from His Honour Judge Harrison in Cardiff, who was also the judge in an earlier case, EUI and Charles, that some of you might be familiar with, which dealt with financial disclosure pre-action. And for the avoidance of doubt, by financial disclosure pre-action, I mean the sorts of disclosure which we see in credit hire cases, bank statements, work slips, tax returns, that sort of thing. And it's often a hot topic as to whether those should be provided for the claims issued, or whether a defendant has to wait until the directions order is made in the case. Understandably, defendants are keen to get their hands on those documents as soon as possible. And in Holt and Alliance, such an application was made. And permission to appeal was granted by the High Court because it recognised that there was a divergence of practice, and some of you may have experienced this, between different courts when dealing with PAD applications in credit hire cases. And some courts make orders for pre-action disclosure very readily, others are very reluctant to do so. And so there was a hope that this decision might promote consistency by giving rise to a binding High Court decision. As we will see, unfortunately, that proved a forlorn hope because the appeal, it was the claimant's appeal, succeeded on a technical ground, namely that the PAD application had been made by Alliance, who was the defendant's insurer, and not the defendant personally. And those of you who've dealt with PAD applications will know that the first criterion in 3116(3)(a) is that the claimant is likely to be the party to proceedings if issued, and the second one is that the applicant is likely to be a party to proceedings. And in this case, because on the fact of this particular case, Alliance wasn't likely to be a party, 3116(3)(b) wasn't satisfied, and so on that rather narrow technical ground alone, the appeal had to succeed. And the effect of that, of course, is that the rest of the judgment is obiter, which, as the judge recognised, could limit its usefulness. However, he does go on to consider the merits in some detail, and I think this decision is likely to be followed and be considered to be highly persuasive in the county court. So it will probably have the effect that was desired when permission was granted. So one of the other criteria in 3116(3) is whether the documents which are sought would fall within standard disclosure if the claim were issued. And on the appeal in Holt, the claimant sought to argue that the sorts of financial disclosure that we all know and love from credit hire cases might not fall within standard disclosure if issued. In other words, it was too early to say whether they would, and therefore that particular requirement could not be said to be satisfied for the purposes of a PADAP. The judge rejected that argument on the appeal and said that the question for the judge hearing the application was whether impecuniosity was likely to be an issue if proceedings were issued, in the sense that it might well be an issue. So there doesn't have to be a high degree of certainty that impecuniosity is going to be an issue, just that it might well be an issue. As you all know, in the vast majority of credit hire cases, it might well be an issue. So that rather suggests that the criteria is going to be quite easy to satisfy. The judge went on, paragraph 82, where the typical ground for impecuniosity is not disowned in the face of a pre-action request to understand the basis of the putative claimant's claim, the only sensible inference is the one drawn by the judge, i.e. that it might well be an issue. So defendants, I think, will find this helpful. The next challenge by the claimant was as to whether a PAD order was desirable. And that's another requirement, as most of us know, under subsection D, whether it's desirable in order to, and then there are three possibilities: dispose fairly of proceedings and assist the dispute resolved without proceedings, or save costs. And again, the judge said that the test was whether the pre-action disclosure sought offered a real prospect in principle of assisting the dispute to be resolved without proceedings or of saving costs. So again, it doesn't have to be a certainty. And he went on, I agree with the judge that where the claim correspondence indicates that impecuniosity is likely, in the relevant sense, to be an important part of the claim, then it's contrary to the letter and spirit of the practice direction not to give serious consideration to it at the pre-action stage. So that's a very clear steer, which I think county court judges will pick up on, that impecuniosity disclosure is likely to be something that's ordered pre-action, if it is indeed sought pre-action. The final stage, of course, under 3116 is the discretion. So even if the four sub-criteria are met, the court still retains a discretion as to whether or not to order disclosure pre-action. And the point that the claimant sought to take in relation to this was to argue that because financial documents are inherently private, that was a factor that should lead the judge not to order disclosure pre-action. And this was roundly rejected on appeal. And at 93, the judge said the plea to privacy and confidentiality is misplaced. The appellant invited and required sufficient intrusion into his financial affairs to warrant the order sought, and granted by asserting a claim for credit hire damages. Went on, the suggestion that a desire on the part of the appellant to protect the privacy of his financial affairs told against ordering pre-action disclosure designed to further the aim of preventing public litigation is in truth somewhat bizarre. In other words, if pre-action disclosure could prevent it ever getting to the court in the first place, that, if anything, would lead to less intrusion into the claimant's financial affairs. So all the more reason for it to be provided pre-action. So that is, again, helpful for defendants. From the point of view of claimants, be aware that this case is going to be cited to you and used against you if PAD applications are threatened. I think it's reason to make sure you get all the claimants' ducks in a row in terms of their financial disclosure very early on in the case, because defendants, I think, increasingly aren't going to be prepared to wait until the claim is issued before they see claimants' financial disclosure. Slight crossover case here in relation to FD, which Roger will be talking about in credit hire, and that's the implications of dishonesty in relation to financial disclosure. What if a party is ordered to provide financial disclosure and they suppress something? They don't supply all their bank statements, for example. Often one finds when you get a set of bank statements, you see money going in and out to another account. And you say, well, where's that account? And lo and behold, there's another account which hasn't been provided. Hayder and DSM demolition is helpful on that. And in that, it was held that dishonesty in relation to financial disclosure can amount to fundamental dishonesty. So if you're looking for an FD finding, the fact that a statement of truth has been signed on a disclosure statement, which ultimately proves not to be true, can make the basis of a finding of FD. And the judge said to emphasize that the importance of the claimant giving proper disclosure of his financial circumstances need to be emphasise part of the purpose of the statement of truth is to bring home to a party the solemn nature of what she or he is doing. By doing as he did, the claimant prevented the defendant from carrying out a proper investigation into his claimed impecuniosity. This skewed and distorted the presentation of the claim in a way that can only be termed fundamentally dishonest. So from a defendant's point of view, useful to know if you want to gun for FD. From a claimant's point of view, be prepared to scrutinise what your client gives you. And if there are anomalies that you pick up, make sure they're dealt with before the client signs a statement of truth and potentially leaves himself open to a finding of FD. Pleading. Now, one of the questions that we were asked in the pre-submissions was about pleading, and in particular, is it absolutely crucial that you plead period of higher rate and reasonableness in the particulars of claim? And the short answer to that is yes. And the reason for that is that it's now part of the amended practice direction to part 16. And I've set out paragraph 6.3 there, which sets out the requirements in particulars of claim in a credit hire case, including pleading need, period, rate, reasonableness, and impecuniosity. And in relation to those, paragraph 6.4 makes clear that in round brackets 2, the obligation to state the matters in paragraph 3 that we've just looked at includes an obligation to state relevant facts, material facts as we tend to call them. So that has to go in the particulars of claim. That's been enforced since April 2020. There may be a few old claims still making their way through the system, but the vast majority of those that you'll be seeing today have been pleaded since then. And so if the particulars don't say that, they're in breach of the practice direction. Perhaps a subsidiary question might be, what happens if they aren't compliant? Well, from a defendant's point of view, you may well be asking for an unless order. These days, it's no longer appropriate, as it has been in the past, to leave this all to a reply on impecuniosity. It has to be upfront in the particulars. And if you get served with particulars that don't have this in, consider applying for an unless order if the claimant isn't prepared to amend of their own accord. And from a claimant's point of view, you need to be very aware of these requirements and make sure your particulars do comply first time round. Dirier and Bojaj has been around for a while, but remains an important authority in terms of what is required in terms of pleading the impecuniosity. The main decision was about a matter we don't need to trouble ourselves with, but there's a useful section towards the end of the judgment which deals with impecuniosity pleading. And specifically, in that case, there was an order for a reply, because this predates the amendment to the practice direction. But in terms of what the order required, it was said the order required the reply to set out all the facts relied on in support of the assertion of impecuniosity. The appellant was a minicab driver, that was the source of his income, so the reply needed to set out what his income was, what his expenditure was, and how those figures meant he could not afford to hire a replacement vehicle. So just saying I couldn't afford to do it, or my outgoings exceeded my income, or anything like that, it doesn't cut the mustard. It has to be figures in the pleading. What about call charges and enforceability? We were pre-asked a question about this, and I think the subtext of the question was what is the potential implication of a call recording? Is it admissible, and if so, what's its probative value? And there's an interesting recent decision in Forster up in Newcastle County Court, where a district judge had ordered disclosure of call recordings between a claimant and a credit hire organisation on the basis that the defendant said they might reveal that there was a conversation whereby the claimant was misled as to the nature of the hire. Either he was told it was a courtesy car, or that he wouldn't have to pay the hire charges. The district judge's decision was upheld on appeal. So to a certain extent, that's helpful from the defendant's point of view. However, that was a decision about disclosure, not about whether the argument would ultimately succeed as to whether what was said constituted a misrepresentation or anything like that. Those decisions on the merits are fact specific, and I've cited a couple of cases there. In Carson, it went against the defendant. In company call center, it went in favor of a defendant, where you have to look at the specific facts in terms of what the written agreement said, what was said during the call recording, but they can be of use in certain circumstances. So look carefully at what's being said. They can be admissible, but bear in mind that if you've got a written agreement which the claimant has signed, that's the starting point in terms of interpreting the contract. And you need to pay careful scrutiny to whether what might have been said in a telephone conversation is admissible, and if it's admissible at all, how probative it's going to be. So that's call recordings and enforceability. What about impecuniosity? An interesting recent case, Morgan Roe. And in that case, the salient facts were that the claimant had about £12,000 in terms of savings, and the basic hire rate would be about £9,000. And the trial judge found that on those facts, the claimant was impecunious, and the defendant didn't like that and appealed and sought to argue that the claimant should have used her savings because there still would have been money left over even if she'd spent out of her ISA. That argument was rejected on appeal by Mr. Justice Julian Knowles in the High Court. He cited the well-known dictum from Irving and Morgan Sindel, where Mr. Justice Turner said that he couldn't ignore the fact that by reducing her capital to the bare minimum and increasing her debt, the claimant would have been exposing herself to the risk of serious financial challenge in the event of even a modest but unexpected financial reverse, which might have afflicted her before her claim was satisfied. And this is a phrase you may well be familiar with: impecuniosity need not amount to penury. So a claimant doesn't have to spend their very last penny before they can resort to credit hire. And on this appeal, the judge found the trial judge had come to a conclusion that was open to him, that the claimant was impecunious. However, I wonder whether judges are still not asking themselves the right question. So in Morgan Roe, the appeal judge interpreted the trial judge's task as being to determine whether it would have been unreasonable in the circumstances in which the claimant found herself to have required her to use her ISA money to pay for the hire car for an uncertain period whilst her own car was undergoing major repairs. But the question has to be asked with reference to and in comparison to what she incurred as a liability to the credit hire company. Asking that question in isolation is meaningless in my view, for the purposes of assessing whether what the claimant did or didn't do was reasonable. Even more muddled, I respectfully suggest, is the following observation in the next paragraph, which is that the flaw in the defendant's argument, i.e. that the claimant should have spent her money, is that it focused on what actually happened with the benefit of hindsight and not what the claimant had to decide immediately following the accident. Well, yes, of course, decisions on mitigation have to be decided without the benefit of hindsight. However, the following section doesn't make sense to me. Because he says at that point no one could have known how long her car would have been off the road or what the hire charge for replacement might have been, either at the spot rate or the credit hire rate. Well, again, if you're comparing what the claimant knew, you have to compare what she knew about credit hire and what she knew about hiring on a spot rate or trying to do the repairs out of her own resources. Both of those are also hampered by her imperfect knowledge. So if she was incurring an open-ended credit hire liability, that was also something that she didn't know how much it was ultimately going to be. So I still don't think questions of impecuniosity are necessarily being framed in the right terms, and I think that the battle will go on in terms of that. What about loss of profits? A very common scenario that we've all encountered, I expect, is where you have a professional driver, often a minicab driver or a food delivery rider, where their vehicle is either wholly or predominantly used to earn money. Many of you will be familiar with Hussein and EUI, where certain exceptions were set out where a claimant could claim credit hire charges over and above the loss of profit which they would have incurred if they just stopped work. And a recent decision in the County Court in Bradford applied that, and that's Mahmood and Liverpool Victoria. It doesn't make any new law necessarily, but I think it's quite an interesting application of Hussein and EUI. Has some interesting observations in terms of whether it's reasonable for a professional driver to continue to work when, if you calculate their actual net profits, they're working for well below the national minimum wage. There may be certain circumstances where they absolutely have to do that for cash flow reasons, but you have to scrutinize that very carefully. And similarly, how should you value a claim where there's a partly profit earning purpose and a partly non-profit earning purpose? And there's some interesting observations about that. It's surprising how often defendants don't get alternative higher rates evidence for a non-plated vehicle, something I think defendants should always do if they're seeking to run a loss of profits argument. So Mahmood and Liverpool Victoria. What about illegality? And again, we were pre-asked a question about this, which I think is going to this issue. We were asked, does exaggeration of hire due to a roadworthy vehicle classed as unroadworthy count as fundamental dishonesty? Well, there are two possible ways that question might be interpreted. One is if a claimant has a vehicle which is they actually continue to use whilst claiming that it's unroadworthy. If they know that it's clearly roadworthy because they're continuing to use it, I think there'd be little doubt in most circumstances that will be dishonest. If it's just that an engineer has told them that it's unroadworthy and it subsequently turns out that it's roadworthy, it's less likely that the claimant personally is going to be found to be dishonest for continuing for not using a vehicle. But more complex legally is the question that sometimes arises where the claimant's original vehicle is not lawfully being used on the road. For example, if its MOT has expired. And the trend tended to be away from disallowing claims on that basis, on the basis of illegality or extirpi causa. And there are a couple of recent Supreme Court authorities in Patel and Mirza and Stoffel and Bondana, which rather restricted that as a potential defence. However, there's more than one way to skin a cat, and in Agbalaya, in the County Court in central London, Honourable Judge Leatham found that there was an alternative way that a claim could be dismissed for credit hire, where the claimant's original vehicle was not lawfully on the road, and that's by essentially a causation argument. In other words, saying, well, if the claimant didn't have a vehicle which he or she could lawfully use on the road before, and then that vehicle is damaged, they haven't actually been deprived of a recoverable loss of use. In Ali and HSF, that argument was subject to further scrutiny, and the High Court approved Agbalaya. And I'm not surprised, because Agbalaya is, although only a county court decision, is a very careful and reasoned judgment. And in particular, they rejected the claimant's argument, which was that really the causation argument and the extirpi argument were just one and the same. The judge said, no, they are different, and that a causation argument can succeed where an extirpi argument might not succeed. So be aware of that. Be aware of the disclosure obligations. If you're acting for a claimant, make sure that your client does have a valid or did have a valid MOT, etc. If you're a defendant, look out for that, because that's a possible way to knock out the hire claim in its entirety. So Ali and HSF logistics are a very important case on that. Finally, I've rather cantered through, but we're working to a fairly tight timescale, so I hope you'll forgive me for doing that. Non-party costs orders. As many of you will be aware, that the whole essence of a credit hire, the whole business model, is to target impecunious claimants. And the upshot of that is, even if a defendant is successful in getting an enforceable costs order, whether because there's no personal injury claim tacked on, or because Quox is disapplied because the claimant is found to be fundamentally dishonest, ultimately that costs order is not worth the paper it's written on, because the claimant tends to be a man or woman of straw. And in those circumstances, it's hardly surprising that defendant insurers see the attraction of seeking to bring in the credit hire company and enforce the costs order against them. And that is a non-party costs order. In Me and Jones, which has been around for a while, it was held that there doesn't have to be some exceptional basis for a credit hire company to be brought in. And you may be aware that in the practice direction to Part 44, credit hire is explicitly referred to as being a claim for the financial benefit of another for the purposes of that part. So it's certainly possible to bring credit hire companies in and succeed against them. However, all of these claims are fact specific, and it may well come down to the exact degree to which a credit hire company has exercised control over the litigation, which is one of the factors that the court must have regard to when considering non-party costs orders. In Shazad, which is one of Roger's cases, the judge held that there wasn't enough to order costs against the credit hire company. So they are obtainable, and it's something that defendants should certainly carefully consider, and I would suggest carefully consider at the outset of an action, not just once it's all done. But neither should it be considered to be an open goal, that in each and every case you can just issue an application and a cost order against a credit hire company will follow as sure as night follows day. They need to be approached with caution. Of course, there's a cost risk if you do join in a credit hire company and ultimately the application is rejected. So a potential route of recovery, but one that needs to be approached with caution. Also credit to Roger for bringing to my attention a very recent decision called Suarez, which is handed down by His Honour Judge Luber Casey in the Central London County Court, where an attempt was made to bring in Annexo PLC, whom some of you may know as the parent company of Bond Turner and McCann's, who of course are very frequent players in this market. And in that case, the application did not succeed. That may again be because of the particular corporate structure of Annexo. So don't take that as being necessarily something that's going to assist credit hire companies in each and every case. But again, it's a cautionary note that it's not a simple case of issuing the application and the cost order follows. But something definitely to consider if you're acting for a defendant, if you're acting for a claimant and or a credit hire company. You need to be aware that you can resist these and look at the facts of the case. And if you're trying to resist them, identify how the facts of your particular case mean that the credit hire company should not be on the hook. So I've actually, I think, come to 2 minutes ahead of my allocated slot. So I'm going to hand over to Roger now, and I'm going to stop sharing my screen, and Roger will be able to share his screen. Thank you very much for attending. If you have any questions, my email address is at the end of this presentation. I'll be very happy to deal with them in writing later. Thank you very much. Goodbye.
Okay, so I'm just going to get my slideshow going. Thank you for that, Roddy. Hopefully everybody can hear me now. Yes, Roddy?
Yes, I can hear you, so I think everyone else can.
All right. So that's very helpful. I know you mentioned that I was going to say something about FD and credit hire. That's not really part of my seminar. That's the only thing I would add is that, of course, there's still this sort of unsettled, ongoing controversy regarding Section 57 PI, whether or not that strikes out credit hire if it's FD. There's the Dior case, the IAW against ERS syndicate management, which supports the claimant's position that Section 57 doesn't apply. There's the old case of Wazir Larazadeh, the former case, which would support the defendant's position. I'm not yet aware of any further higher court or otherwise settlement of that decision yet. There's obviously a bit of a stalemate from a defence perspective. it's really a case of whether or not one is instructed to make such an argument. I was instructed to make that argument maybe about 6 weeks ago, and the court did strike out the case under Section 57. But it's a controversy which is ongoing and not settled, in my view. If you know anything otherwise, let me know. Now, so far as my session is concerned, fundamental dishonesty, it's a risky business, litigation that is. So I'm going to touch upon some of the key recent developments in PI and FD, fundamental dishonesty. Arguably, there are significant positives for both sides, mainly for the defence/stroke insurer. For example, dismissal for the defence would be dismissal of claimant's FD claim under CPR 4416, resulting in removal of box protection, and thereby enforceable costs against the losing claimant. There could also be dismissal of damages to which a claimant would be entitled to, but for the finding that the claimant has been fundamentally dishonest in relation to the primary or related claim under Section 57 Criminal Justice Courts Act 2015. Under Section 57, costs save deduction of the declared award C would have been entitled to, but for the FD. Now, potential indemnity basis of assessment of costs is also an advantage to a defendant, and based on the conduct of FD being out of the norm. Now, policy considerations may also be a benefit to the defendant who would wish to perhaps publicise the finding of FD and perhaps go further and positively escalate to contempt proceedings or seek private prosecution. Now, for the claimant, whilst there are risks to the claimant, of course, of costs and so on, and indemnity costs, for example, just losing the case, nevertheless, the prospect remains for potential compensation and solicitor costs. So aside from those risks, other potential positives for the claimant might be that the burden of FDs placed on the accuser, the defendant, a hardening of the court's stance, albeit the civil standard, a hardening of the court's stance due to FD allegations and tiredness of them, let's say. If successful, the claimant can seek indemnity costs potentially for the manner of the running of the FD defence. So with all this at stake, it matters ranging from relatively modest claims to significant claims as to the application and judicial interpretation of fundamental dishonesty, which has proved a fast-moving area of law. Now, so far as interpretation is concerned, Ivy and Genting Casino, this matter concerned cheating as alleged by casino gamblers' method. It was found that the court must be satisfied subjectively what the claimant's state of mind was at the relevant time, and the objectively against that background whether the ordinary person would find the claimant's conduct to be dishonest. As to fundamental, the line of cases, Howlett, Lockall, and Sinfield, and so on, with phrases such as not collateral or minor, but the dishonesty goes to the root of either the whole of the claim or a substantial part of it, or a claim which depended to a substantial or important part of itself upon dishonesty. That's Howlett. Now, as far as Lockall is concerned, in terms of dishonesty, potentially adversely affects the defendant in a significant way, and by substantially affects, it's intended to claim the same idea as the expression going to the root or going to the heart of the claim. Now, more recently, in the case of Pajano and Essex, got the citation there, concerning a personal injury claim following negligently delayed treatment on the fingers and a hand, Justice Ritchie set out a 5-stage test, paragraphs 47 to 49. You've got that there in the slide. And I will come back to number 1 as to pleading later in this session. But essentially, you can see that the test of IV-genting is incorporated in there, and the burden, the civil standard, and so on. Now, recent examples of FD allegations at trial. So starting with that Pajano case, the claimant had been dishonest about the circumstances of his injury to his fingers. He was on remand at the index, and whilst he blamed his wife for the injury to his fingers, he was eventually convicted of attempted murder. So whatever the origin, his finger injuries gave rise to medical treatment, which was negligently delayed, and this dishonesty as the origin of his injuries was found at first instance to be fundamental. However, the FD finding was overturned on it, as it was found that the dishonesty was irrelevant to the clinical negligence of the delayed treatment. Furthermore, the schedule of loss that had been incorrectly pleaded was the fault of his representatives, not him, it was found. So Mr. Justice Ritchie stated that I consider that the incorrect pleading and the failure to quantify the claim properly by the claimant's lawyers in the schedule is not in this case fundamental dishonesty. It was not dishonesty at all. In addition, on the facts of this case, inadequate pleading is not within the mischief which Parliament aims to prevent, nor is incompetence, carelessness, negligence, or mere omission by the lawyers. The section requires proof of the claimant's dishonesty, not his lawyer's lack of competence. And that can be really quite a awful thing from a defence perspective, because of course they've run it to trial, and we see this in county court at the coalface, running to trial with all those attempting to put the inconsistencies forward and so on, and having good points. But sometimes it has to be that a judge will say, well, blame the lawyers, not the claimant. And that is the sort of case where that's occurred. Now, in so far as the next case, Denzel and Mohammed is concerned, Mr. Justice Friedman overturned a finding by a trial judge concerning a PI RTA claim that the claimant had been FD as no head injury had occurred. The finding that a minor short-term head injury, which was not part of the claimant's appeal case, or the longer injuries to the back and so on, and special damages, was fundamental dishonesty, was overturned. It was found on appeal that the head injury issue was not fundamental. It did not affect the value of the claim or the way the case had been presented, or even pleaded within it, or not even in the medical report. So the first instance judge also, it was found, lacked reasoning for the finding of FD. Now, next case is Moyeka, 2022, where Mr. Justice Cotter ruled that the claimant's entire claim for damages following a non-freezing cold injury, though pleaded at no 3 million, was actually worth less than 100,000, and the 97 in fact, and the whole claim was struck out pursuant to section 57. After a 12-day trial involving multiple lay and expert witnesses, it was found that the claimant and his wife cannot be accepted as truthful or accurate. The claimant had claimed that he could only walk a few meters before the pain became too severe, and he used a walking stick every day. He claimed his wife provided ongoing care for him. It was found that major parts of the testimony of the claimant and his wife could not be accepted as truthful or accurate. Further, video evidence of the claimant at a wedding in 2019 showed him walking normally in a casual fashion, was devastating to his credibility, as the defendant experts found it to be. Now, although this case example of a high value application of FD, but which does not really break new ground regarding FD, it's still an example of the high value application. But it nonetheless is still important lessons, for example, as to other issues concerning pain experts and the concept of conscious exaggeration of a valid claim that struck out. And further, that particular case involved criticism of the claimant's experts in the case, particularly the care expert, as to the content of reports, and the court reminded the experts of their overriding duty to the court. An interesting and damning point regarding experts there. Now, in the case of Manti and MOD 2023, more recent, In 2017, the claimant was deployed military to Estonia, where he was evacuated following a non-breathing cold injury. He subsequently claimed 1.6 million PI. The claimant said that he struggled with poor balance due to pain in his feet, legs, couldn't walk long distances, felt low, unable to drive long distances, and found it difficult to concentrate for long periods due to the amount of pain he was in. Mr. Justice Eyre said the surveillance footage in that case shows Mr. Manty walking with a normal gait, without limping, and without using either a stick or a crutch, carrying a garden parasol, and so on. So the claimant's assertion that the inconsistency between his pleaded case and the video evidence obtained by the defendant was due to the latter being obtained on a good day, the old argument of good days, bad days. But the claimant was found to be fundamentally dishonest, with no other reasonable explanation for the inconsistencies highlighted by the videos. The difference between his presentation to the defendant's expert and the video was marked. The claimant's contention that the video was taken on a good day, pain and undermined medication, was rejected. Now, there's further cases in terms of recent developments. This Carmen Aviva involving claims layering, it was handed down in 2023, a case in which I was for the defendant and has been reported widely elsewhere. Now here, the fundamental dishonesty was found against the claimant regarding a low-speed RTA, and who was found to have accusatory made a fundamental dishonest claim, PI. But in addition, and of wider significance, following cross-examination of the claimant's witnesses and the presentation of similar fact evidence, first instance of the county court, District Judge Lum found it to be a powerful and persuasive in demonstrating a similar pattern of action in numerous cases involving the same firm of solicitors, the medico-legal practitioner and the clinical psychologist, the medical agency, all with common claims for CBT and physiotherapy, as was presented in this case. District Judge Lum found that, in my judgment, this is clear evidence of the layering of this claim and others as alleged by the defendants. The claimant, having been involved in the road traffic accident, not her fault, took a chance on bringing an opportunistic claim for damages. It may be that her initial dishonesty was only in relation to whether she was injured or not, and the extent of those injuries, but she then found herself caught up in a business model that was being operated by others that she could not escape from, and had to play her part in seeking to cover up the activities of others. In that case, also during my cross-examination, which District Judge Lund described as my unpicking of the threads of the cane, the claimant also was discovered to have been using a crib sheet, and that's something further that the judge commented on. So, as far as the similar fact evidence issues that were approved in that case, see also the case of Roderick, where it's important to note judicial recognition of claims layering. Claim layering is in the Khan case, but in the Roderick case, permission was granted to rely upon similar fact evidence of similar facts regarding claims and a certain solicitor. So, next section is discontinuance and quotes. I cite there the case of Excalibur 2023. This was an employer liability matter involving discontinuance prior to the giving of evidence by the claimant. The judge asked the parties to go and consider the case, the evidence and inconsistencies. So the defendant sought to set aside the discontinuance, strike out the claim out, and for removal of court protection under CPR 44.15c, on the basis that such discontinuance was an interference with the just disposal of proceedings. The Court of Appeal actually approved the first appeal of the County Court, which overturned the first instance judge's finding, who had indeed set aside notice of discontinuance and removed court protection. On that second appeal, the Court of Appeal found that there was no need to approach CPR 38.4 and the setting aside of notice of discontinuance any differently in the PI case, which Fox applies, the court emphasised claimant's decision to discontinue, having weighed up prospects of success, was of course the conduct taken by many litigants, and does not begin to provide powerful reasons on which to note a notice of discontinuance should or could be set aside. Evidence of abuse of process or similarly egregious conduct is required to deprive the claimant of his right, subject to limited exceptions, discontinue. So, although disappointing from a defendant's perspective, it should be noted that a factor was dishonesty had not been pleaded in that case. And so now I return to the issue of pleading, mentioned earlier about Cojanu. For pleading in the FD defence as setting out a requirement in Cojanu. Now, I suggest that this is not consistent with the approach of courts more generally, historically, which is more reflected in the case of Howlett, relied on by courts and many defendants in the Court of Appeal, who placed no such strict requirement. In Howlett, it was held that provided there was enough material in the pleading to give the claimant notice that it would be taken at trial, there was no need for fraud to be expressly pleaded. Cross-examination sufficed, provided the points to the claimant. However, caution is of course expressed insofar as that the adequacy of the notice, for example, if expert witnesses need to see it before the trial, so rather than just at the trial examination. But though express pleading of the defence is not bar for such a finding, a litigant in person, in another case, was found to have not been given sufficient notice and opportunity to deal with submission of FD, first expressly put during closing submissions. That's the case of Jenkinson and Robertson. Correspondence referring to exaggeration, section 57, was not adequate notice, absent at least putting it to the claimant in examination. Of course, take note that's a litigant in person, with special care, but in any event, of course, you must at least put it in the cross-examination to the claimant. So that's my section, and the questions at this stage. But thank you very much for, if there are any, you can always email us later. I'm sorry, I've just heard that I've been cutting in and out, and I can only apologise for that. But if there are any questions, please feel free to contact myself or Roddy. You have the email address there. And thank you very much.